Governor Abell. He sent an email. I thought he was on.
Here.
Oh, there he is.
I'm here, Mr. President.
There he is.
Thank you.
Governor Adwale. Governor Angeville.
Present.
Governor Boyd.
Here.
Governor Clark.
Here.
Governor Couch, I think, is joining us later, or is he here? Governor Dresden.
Here.
Governor Higginson. Governor McBride.
Here.
Governor Peterson.
Here.
Governor Pertzer.
Here.
Governor Sayani. Governor Stevens.
Here.
Governor Williams-Ruth.
Here.
Okay, we have quorum. Welcome, everybody. I believe this is our third ETHOS meeting. And the purpose of this meeting is to try and get as much input from different stakeholders as possible. So we have set out different time frames for different groups to please come and share with us. The first group that our association's present. You could like hold up your virtual hand. Anybody see any virtual hands? Okay, well, we can wait. We scheduled an hour for that from 9:05 to 10:05. What we could do is possibly go to the next group. I know we have some representatives there or here. And then go back. If we start getting virtual hands from the minority bar associations, I don't want them to feel like they're being cut out or anything like that. So maybe we can send a broadcast message saying, gonna go to the next group, because I know we have representatives here from those groups. And come back to the minority bar associations when any representatives show up. Anybody object to that? Okay, we have some folks here from different sections, I know. Oh, you're objecting? Former President Majumdar, what do you have to say?
Thank you, President Tolson. I just wanted to note, I was trying to get into the ETHOS meeting and I couldn't. I'll just note for the record that on the agenda, the link is for the June meeting, so that won't take you here. And on the sidebar column, the address for the Zoom meeting won't let you in unless you have a passcode. You have to use the main page link. That'll get you here, but I don't know. Maybe somebody needs to reach out to any MBA representatives that were going to come to let them know the right way to get in, because I was not able to figure out my way in for quite some time. Thank you.
Thank you. Yeah, I don't have, there probably is a list somewhere that we could broadcast to the different representatives of the minority bar associations. Okay, let's move on then and try and come back to use the time of people who I know are already here. We have at least, who do we have that might be, could you raise your virtual hands if you're a section representative? Two real hands, I know. Then we have John Strait. At least 3 representatives so far. So John Strait, welcome.
Thank you.
I'm going to let you talk first.
Well, I appreciate that, but I'm actually more observing for the section than I am taking a section position or presenting for the section. We're running a little slow to the game here, and I'm assuming we have a little more time than we all thought we did, given the Supreme Court's actions a week ago. And so the immediate crisis is not as serious as we might have expected, since the Supreme Court's denied cert on all the circuit opinions. So at this point, I'm primarily an observer. I know that the section generally is in favor of maintaining the, to the extent possible, the existing unified structure of the bar. And I am quite familiar with the case law and the issues. But other than making that generalized statement, we really wanted to learn more about what exactly is being discussed.
Which section are you a member of?
Crim law. I'm on the executive board of crim law section and have been for, I'm sorry to say, decades.
Okay, well, you should know that we're having discussions. We felt like we didn't have enough time to get the message out to everybody, but we're having discussions about the focus on, as you know, the Supreme Court asked us to answer 3 questions. The first question is, do we have to make any immediate changes? And I think because of the cert denied on those 3 cases, the answer to that is probably not.
Yes, I would agree with that.
Yeah, and then the next 2 questions were, regardless of the answer to question number 1, basically, have you got a backup plan should things change, and develop that backup plan? So that's question number 2, and I'm paraphrasing, obviously. And question number 3 is, regardless of your answer to questions 1 and 2, in the interest of justice, kind of a big phrase, what would be the best structure for the bar to have? And so we are definitely going to be focusing on 2 and 3, and definitely focusing on 3. So have you got any thoughts that you want to share about what you think the best structure of the bar association ought to be in the interest of justice?
I have lots of thoughts, but I'm not really feeling very comfortable expressing them on behalf of the section.
Okay.
Because that's not something that we have had. The section asked me to attend this because of my prior involvement with bar structure and the bar in the past. And I have a lot of opinions, but I haven't run them past them. And it's very helpful for you to summarize the 3 questions presented. I will take that back to the section, and I will have a lengthy discussion, and I will present that material either in writing or if we have another ethos section in that session.
We do have more meetings scheduled. The next one's going to be in July. It's going to be over in Spokane. It's going to be on a Saturday right after the 2-day Board of Governors meeting over there. So that might.
Yes, I'm sure we'd be able to.
Oh, I'm sorry. Yeah, the July one is focused on getting more public input. We have a June meeting too, but the July meeting's designed for that. Are you representing a section, past President Schicchetti? I'm not. Okay. Do you have some thoughts that you want to add at this point?
I do. I don't know. Is my mic working? Okay.
Oh, it is. Good.
Governor Stevens was ahead of me, though.
Mr. President, should I go ahead?
Yes, please.
Okay, I just wanted to, for the record, note that maybe even in our process, looking down the road, so there's one thing to do the open call, asking people what their views are, opinions, but we should certainly have another round if and when we come up with a proposal that people can then actually react and respond to. So it's just, when in the iterative process.
Thank you very much for that. Okay, past President Shichetti.
Yeah, just briefly, in response to some of the comments that Mr. Straight made, you know, while there may be time, keep in mind that there is a Ninth Circuit court case out there that's been remanded back down to the district court that says that there's a valid claim for freedom of expression and freedom of speech. And depending on what happens in that court, we could have very different law in the Ninth Circuit, and that could happen soon. So I don't know that we can say that we have a lot of time because the Supreme Court has denied cert. And in fact, one of the judges on that panel suggested that if successful, the Oregon State Bar would have to restructure itself. And so that's what we're looking at now too. And then the second comment I would make is that, you know, while the three questions that Chief Justice Gonzalez posed to us a few months ago are important, and we should address that, we also talked about having a backup plan. So if the court comes and decides that we need to restructure, or if the Ninth Circuit says that we need to restructure, then we might want to consider, you know, what happens in that circumstance. So there's lots of work for us to do, and I don't think we should be we should delay, and I don't think that we should think that we have a lot of time, because we might not.
Thank you, past President Shichetti. And that was question number 2, and I did cover that in my discussions with Professor Straight. So I'm perfectly aware of that, and everybody else is perfectly aware that we need to answer both questions 2 and 3, regardless of the fact that question number 1 might already be answered. Okay, I think we are on to some more section representatives, and we have 2 people in the back of the room. And I know that Nancy Hawkins is here, but the other gentleman I don't. Here's right. If you could have a seat there, and then if you could tell us your name and tell us what section you're representing.
Okay, I'll do that. My name is David Rose. I am on the executive committee of the litigation section, and I see my role today in much the same way as Professor Straight indicated, as an observer, participant, providing some feedback, but not making a specific recommendation for proposed reform or a maintaining the status quo. Some of the issues, I think, from the section standpoint, are front and center in this process, in that what we do, at least in the litigations section, is pay attention and always keep our eye on promoting the fair and equitable administration of justice in the state. And when there are bills or proposals in the legislature that may impact on that negatively or positively, we like to take a look at that, vet it, use our experience, and make comments as a committee in accordance with our rules, our guidelines. And we're very judicious in that approach, because we realize some of the issues that are presented in these court cases are that we may be taking a position on a particular issue that some folks might not agree with, or think that it's outside of our bailiwick. But you can't avoid that kind of analysis, because it's in the nature of this practice, and the administration of justice is a broad, expansive concept and value, and so we take that very seriously to make sure that we can provide expertise, collective experience on these important issues, to assist in the legislative referral process that we play a significant role in. one issue, and I happened to read prior to my coming here this morning, there was some comments from some other sections, and one was, and it's relevant, it's a remote Zoom, the suspension of everything being in person. And we looked at that issue as it might affect certain rules about trials or hearings and such. And the implications of that policy or that change in course are significant, profound changes that we need to step back and look at. For example, what do you lose when trials and hearings, fact-finding tribunals are operating using remote technology and witnesses that are not present, with juries, and all kinds of the implications for the administration of justice are very serious. And so we looked at proposed changes, and we spent quite a bit of time looking at that to see if we would take a position if such proposed rules or changes are coming down the road. We haven't taken a position on that because we're still in a preliminary stage of analysis, but and by our section rules that in order to take a position, we have to have a certain majority of the executive committee that are in agreement with a particular. So there's kind of a built-in safeguard for, fair decision-making processes for the sections that are weighing in on these issues. But I just want to stress the importance, not that I'm beating the drums for the sections, but the litigation section in particular, we play a role in the regulation and the profession as it's practiced and how we can improve that, and also the administration of justice and the court rules and all the procedures that govern day-to-day lives for so many of the folks in our state. And there's been all kinds of reports out there that we have a civil justice crisis, in that it's very difficult for folks to be able to afford civil counsel in administrative and other civil cases, and that's a problem. And these kind of issues come up in proposals that we review in the litigation section as to how it will impact on the profession, of course, but also the people out there who need our services. And it's a broad segment of society, not just those that have connections to legal services. So I just wanted to make that comment that I believe what we do in the current bar structure is important. It's worth preserving, and any way we can strengthen it and improve our section processes and our bar processes so that this is taken into consideration will be extremely appreciated, and I think we'll all be well served.
Willing to answer any questions if anybody has questions on the Board of Governors.
Sure.
I don't know if anybody has any questions for David Rose. Seeing a lot of hands up. Professor Straight's got his hand up, but he had his hand up before David Rose spoke.
No, I put it back up.
Do you have another? Do you want to say something with respect to what David Rose had to say, or?
I wanted to second it, and I maybe should have pointed this out, but I'm assuming the Board of Governors knows that the criminal law section executive committee is by rule required to be half prosecutors and half defense-oriented folks. And we only take positions if we have a supermajority And we are the only organization that exists in which there are both prosecutors and defense voices. So if we take a position on litigation or court rules or things like that, it really does represent a significant consensus. And I would be very concerned about a change that would prevent that influence over what we already deal with. And much as in the civil justice side, we deal with the impacts both as prosecutors and as defense counsel on behalf of very large swaths of the people that are involved in the criminal justice system. That would be a terrible voice to lose. We'd leave it only to the advocates who present their advocate positions, WAPA, for example, and Washington Association of Criminal Defense Lawyers, Washington Defenders Association, all of which exclude the opposite perspectives. I'm assuming the board knew that, but maybe I shouldn't have made that assumption. So I wanted to second his comments. I think they're extremely well taken.
Thank you very much. Appreciate it. Anybody else have any questions, thoughts, or observations with respect to what? Okay. Maybe I could have the executive director read the chat from our president-elect.
Yes, the question from President-elect Dan Clark is, question for Mr. Rose and the section representatives. If you're speaking on behalf of your section, have you reached out for public comments and or a vote from the actual members of your sections, or are the comments only from the executive committee of the section? What outreach have sections done to their members to solicit input before coming to the Board of Governors with their viewpoint?
Speaking for the criminal law section, because we don't have a position that has been distributed yet, no, we will distribute it to our membership once we have one, either from the board or from the executive committee. But I'm appearing here at the request of the executive committee.
And that would be my answer as well. These issues have been discussed in the committee, but we have not taken a position, concrete position on anything yet. If we decide to do that, we will solicit the opinion or the input from our membership as a whole. I think that's very important. It's part of the inclusion that we like to have in this section. I would just like to make one other comment that I thought about when Professor Straight made his point about having prosecutors and defense attorneys reflecting a broad, diverse section of the community as defined. We try to do that in the litigation section, and I know very well because I'm on my second tour of duty. And I know we have in the past and continue to do, try to make sure that we have a balanced litigation committee, different types of lawyers from the east side of the state, which is where I come from, and the west side of the state. If you don't make a determined outreach, you end up with mostly west side attorneys, which they're fine, great attorneys, competent. No criticism there. But it is also nice to have, Spokane, Walla Walla, the southeastern Washington represented as well.
Sorry. Anybody else have any other questions, thoughts, or comments with respect to what Professor Straight and Mr. Clark have said? And I'm not ignoring Nancy Hawkins, because I know she's going to get up in a minute and tell us a lot. Great. Thank you very much to both of you folks for being here. Appreciate it. And please stay involved in this process and stick around for the rest of the meeting if you would.
Thank you.
My microphone's on. Can't hear me? I'll just stick it right in front of my face. It's always so attractive. Okay. Oh, is there a hand up on the phone?
Yes, Mr. President, can you hear me?
Oh, yeah, there you are. Governor Stevens.
Yeah, no, I just wanted to state that when I heard President-elect Clark asking the question about, did you go out to all of your members? I just want to be clear that in the general course of how the sections operate, there's a great deal of trust given to the executive committee of those sections who do the lion's share of the work, including, for example, comments on legislation, et cetera, et cetera. So I would not want us to now erect a requirement that executive committee, you may come to us, but your opinion is not as well received if you didn't go out to all of your members to find out what they wanted you to do, or to find out what their posture is. I think it's one thing to ask the executive committee to keep their members informed. I think it's a whole other thing to erect a requirement of some sort or a judgment that if you don't do X, if you don't go out and have sort of a plebiscite, that your views are not well taken. They should be very well taken, because that's basically the ongoing work of section executive committees.
Thank you very much. We have Billy Baxter on the Zoom portion of the meeting. Welcome. Are you here representing a section?
Hi, my name is Ellie Baxter. I'm the
Oh,
chair.
I'm sorry.
Hello, can you hear me?
Yeah, I'm sorry. I couldn't read the fine print on my Zoom screen. It's Ellie Baxter. Welcome.
Thank you. I am the chair of the International Practice section. So I do have an opinion. We discussed just a little bit with the executive committee, and I just would like to, at this point, comment that Mr. Clark's point made in the chat box, and just a gentleman commented on that. And actually, I am in the same opinion. So the question if whether we reached out to our section members. So we are still learning about these complicated issues. So we are not we're not in the position to explain what is going on to the membership and get opinions. And so what I guess what I'd like to suggest is that maybe the Washington State Bar Association staff can have a meeting with section leaders and explain what is going on, and with summarizing these issues, and then that would be very much helpful for section leaders to understand. And then maybe if you can also provide some materials we can distribute to our membership, and then we can communicate with our membership. But as that gentleman just suggested, we executive committees are responsible to speak on behalf of our membership. So we should be able to do so. If reaching out to entire membership is, for instance, burdensome to some like large section members with like 1,000 or 2,000 members, and then section executive committee members should be delegated to a voice for their membership. And so I don't know which how executive committees committee members should voice their each section members' voices to this board, but that's one thing I can suggest, because I also regularly attend section leaders meetings, monthly meetings, and what's been discussed among section leaders and learning from this meeting by the Board of Governors.
Yeah, I'll let you.
I have mixed information and still trying to understand. So some holistic educational session provided by Washington State Bar Association staff members to section leaders would be appreciated. Thank you.
And I think Director Plachy has some good information for you about helping the section leaders come up to speed on all these issues. Director Plachy.
Can you hear me?
Yes.
Thank you, President Tollefson. Yes, in response to Ellie's comment, Ellie, there is a spring section leaders meeting that's taking place next week. And on that agenda is a full conversation of the structure, the process of this meeting. We also have about 4 or 5 governors that I'm aware of who will be present at that meeting to answer section questions as well. So anyone that's listening on from the sections, I would encourage everyone to attend that meeting next week. It's the spring section leaders meeting. I believe it's, I think it's on the 8th and it runs 28th. I'm sorry, it's a Wednesday, isn't it? I'll put the date in the chat in Zoom so everyone has it, but it is the spring section leaders meeting. It's occurring next week, and there's a placeholder on this where we'll be going over this whole ethos structure issue. And in fact, our executive director will be there to give an overview of this whole process.
It's Wednesday from 3 to 5.
Yes, thank you.
There you go. I think our executive director would like to add a footnote to that too.
Yeah, one more thing I wanted to note is if you go to the structure webpage on the WSBA website, there's a lot of resources, including a 10-minute video that summarizes the issues. So that is also something I would encourage. It could be sent out on your listservs, shared with members, and I think it's a good way to get up to speed on the issues.
Any follow-up questions from Ellie Baxter? Any follow-up questions for Ellie Baxter? Ellie Baxter, you still have your hand up. I didn't know if you had something else you wanted to share.
So then just a point I would like to make on behalf of our section. So for our activities, we believe that, well, at least the executive committee believes that WSBA does not need to change current structure, or more specifically, we would like to advocate that section should remain under the WSBA. As for our activities, we provide monthly CLEs, 2 annual events, mentorship program, and scholarship program for law students. The WSBA staff has been supporting us wonderfully, especially for monthly CLE. So we regularly communicate with mini CLE team, not only when we provide CLE by using their webinar tool, but also third parties platform, meeting law firms. And for example, last year and this year, we provided like 9 or 10 mini CLEs per year. And in order to do that many activities, we really need the WSBA's support. And so the name of the WSBA really gives us a value. For instance, last September, we had a speaker, CLE speaker from Harvard Law School professor from Cambridge, Massachusetts, and on the topic of corporate liability under the Alien Tort Statute. And then we had a great turnout for that. And also in January, we provided CLEs, well, free to all members, anyone, not only to our membership, but also to all section members or all Washington members or any other lawyers. And over 200 people attended that meeting. That was the record high attendees. And probably WSBA staff knows that. So we have to make sure the registration and also type in the system, all those attendees obtain CLE credits. I remember doing that by hand when I was doing so for Lawyers Association, not under the WSBA. And we cannot do that if we do not have the WSBA support. And also, the name of the WSBA really support us to recruit executive committee members, because it shows that we are not just a lawyers group, but we are trusted lawyers under the Washington State Bar Association. So all these values make our activities possible. And just, giving like free CLE to over 200 lawyers, I think that is a great benefit to legal communities. Thank you.
Thank you very much. Governor Stevens, do you have your hand up again for another question or? Okay. Nancy Hawkins has been very patiently waiting her turn, and it's time for you.
I'm not hearing anything.
Morning, everyone. Good to go? The family law section has been very active over the years, and we have remained active with regard to the structure issues. They're very important to us. There are certainly things that we have identified over the years that we would like to see changed from the Bar Association, but completely overhauling our structure is not one of them. We frankly see it as a mistake for both sections and for the Bar Association as a whole. We contribute to the success of other sections. We contribute to the success of the Bar Association overall, and we receive a benefit as well. With regard to the three questions, I think that with the denial of cert, I haven't heard anyone disagree, but that the answer to Washington Supreme Court question 1 is no. Does current federal litigation regarding the constitutionality of integrated bars require the Bar Association to make a structure change? No, it does not. And I think we should be thrilled by the denial of cert. I choose to think of it as that this fear that the Supreme Court was about to issue a decision that all integrated or mandatory bars would be unconstitutional, that fear that we've been living under for years, that has been expressed many times, many ways, is turned out not to be the case. And can there be future cases? Sure, we'll wait and see what those future cases are. There's no need to rush. The answer to question number 1 is no. And I think that we should continue to believe that our structure is sound and that we do not need to worry about some sudden change in our structure. with regard to question number 2 about a backup plan or a contingency plan, I think that's a mistake. It is, first of all, I think it's impossible. And when I say these have been discussed with my section. Our section is united on this topic. Our executive committee is united on this topic. And yes, and I'll get into that a few minutes from now, but we have solicited information from our members, but not asked them, do you want there to be a change in structure of the Bar Association? Because that's a question that they're not prepared to answer, that we work very hard to be able to answer as an executive committee. And as Ellie Baxter told you, it's a complicated issue, as you know, because as governors, you have worked on this for years, months, hours and hours of reading. And we cannot expect members who have active practices, active jobs, to sit down and spend 100 hours learning about something before they answer a question. We all know how much time we spend on these survey monkeys that we get. We spend about 10 seconds. You know, do you want to see structure change in the Bar Association? Hell yes. What are the details? Don't know. That's what we'd get back. What do people want? We hear about it all the time. They want to be out of Seattle. They want to pay less money. Okay, what does that really mean? What would be the consequences of that? How much does it cost? We hear requests for a satellite office. Okay, what's involved in that? What would be the purpose of a satellite office? Who would be there? If the Bar Association's doing less work, why have a satellite office at all? What does it matter if our office is in Wenatchee or Spokane or Seattle if it's only doing one thing or two things? So a contingency plan would have to have 50 different options. It's an impossibility. When and if a case comes down that is directly applicable to us, not stretched one direction or another to maybe make us worried about what if something happens here, but directly affects us, a U.S. Supreme Court case, a Ninth Circuit case that invalidates a program we do, then yes, we should tweak that. But because Texas or Oklahoma or Louisiana does something one way, does not mean that we must run scared and do it their way. I have long advocated, our section has long advocated for us as an organization to be proud of the things we have done, proud of the programs we have for the analysis we do, most particularly the Keller Deduction, which is calculated carefully each year, supported by data, and addresses the issues that are of concern in other states. Why would we run to imitate a state that doesn't even have a Keller deduction, or has a Keller deduction that requires that somebody go beg for it from their executive director or the president of their board, and requires that member to determine the amount of the Keller deduction? No, we should be a leader. We should be telling other states, here's a good way to do this, so that if someday we're in court defending what we do, well, it's defensible. It's completely defensible. We shouldn't be afraid of that. We hear a lot of talk about dissenting members of the Bar Association. So let's talk about the things we often hear. And I already mentioned the satellite office issue. So lower dues, great. Let's reduce the dues $300, and that's going to solve the problems of every lawyer or every litigant in the state of Washington? Of course not. It's not going to fix anything. It's an amount of money that the difference over the course of a year is not meaningful to individual lawyers for the most part. Now, are there things we can do to tweak that? Sure. An issue was brought to us from the senior lawyers. Senior lawyers still want to be active, be considered active so they can continue to do pro bono work into their retirement. But they don't want to pay more in dues when they're on a fixed income and they're no longer working. So the Bar Association looks at that. They study it. They figure out the financial impact. What if those senior lawyers pay less money? But we get a greater benefit because they do pro bono work. So what's wrong with that? What's wrong with having a structure that can identify a problem because we're all together in the same room and then comes up with a solution? You know, reading the comments that have come in raised other issues, both now and in the past. We learned about problems of rural lawyers. So we worked on having a project to help meet those needs. We don't ignore it, but we wouldn't even have learned of the problem if there wasn't a full room with people across the state in various areas of the law able to identify problems. I noticed Mike Cherry on the screen when this organization was considering having mandatory malpractice insurance. I remember Mike talking about the problem of people in his field getting insurance at all because they work in fields that are so, well, they're beyond my understanding, that's for sure. But they work in fields that make it difficult to get insurance. So the organization as a whole learned about a problem, worked on it, and tries to come up with solutions. That's why there's such a benefit to having everyone in the room. We learned that, I learned from some of the comments, some restrictions or requirements on out-of-state lawyers that I didn't know existed. Having to have a resident agent and different things. Okay, so now there's an issue that's been identified that probably the rest of us who practice here weren't aware of. So should this organization look at that and see if there are other solutions? You know, are there other ways to solve the problem that was somebody thought better solved by requiring resident agents? I can speculate what the reasons were, but maybe there's some other solutions in this day and age that would make that better. I think we learn a lot by being together. We learned a lot. We also learn a lot, at least I know I do, when on an annual basis we hear at the Board of Governors from the law school presidents or deans. We learn about the struggles of students that we might not otherwise know about unless you have a child in law school or a paralegal in your office going to law school. I learned a lot. I think it was Jordan talking about the bar exam and its history. And then we heard a lot about whether the bar exam helps only pass qualified lawyers or doesn't. If we're all split apart, we're not going to get the input that we need to get. And frankly, you get a different group of governors because most of you, I would assume, ran for governor because of your expertise in a particular subject area or your interest in subject area. But you probably aren't interested in only doing licensing issues or only managing a discipline program or those sorts of things. You want to see the organization have some substantive value, and you can only have that if this organization continues to do more than just licensing and discipline. I saw the letter from the taxation section, and very similar to the family law section's point of view, which is, we gain strength working together. our opinions are stronger if we have the Bar Association seal behind our heads when we're talking. But it's also, like I said, the other way around. The Bar Association is made better because when the legislature calls and has a question about a piece of legislation, do you think this would work to solve X, Y, or Z problem? That a section can step up and say, it won't solve that problem because of A, B, and C, but maybe if we tweaked it, it would. Here's a suggestion. The problem's identified, solutions are created, conversations happen, discussions happen. Should this organization be initiating legislation? We don't do it very often. I'm not sure it would matter if we didn't initiate legislation, but commenting on legislating, providing technical advice, advising legislators of unintended consequences of bills that they propose, that's exactly what we should be doing. There have been years there are no lawyers in the Washington State Legislature. I can remember when that was the case. There still aren't that many, but I can remember years there were none. Well, it's kind of mind-boggling to think that an entire legislature of non-lawyers are responsible for writing laws, and they couldn't get advice from groups of people with specialized knowledge. It makes no sense. Structure change is a huge issue. I frankly don't know why we would be seriously trying to do this at this point. And, thinking back an hour ago to the beginning of this meeting when there was a whole bunch of mic issues and feedback issues and can you hear me kinds of, comments. And the Bar Association has pretty fancy equipment. Well, if the sections are off on their own and the committees are off on their own and who knows what is off on its own, will there have to be 30 different sets of mics and meeting rooms and software? It wouldn't succeed. You would weaken the other work of the people involved in this organization to an unacceptable level. But it's not just that sections need the help of the Bar Association, because after all, we pay for it. I noticed from some comments a couple years ago and now that people seem to think that sections get a lot of free stuff from the Bar Association, so that somebody's dues that are paid in Everett somehow doesn't benefit that member. Well, the truth of the matter is sections pay a per member charge. It's calculated, even if I do argue sometimes with Kevin on the calculation itself, but there is a per member charge for the benefits that sections receive out of licensing. And then the sections pay that money out of our section dues. So somebody who's not involved in a section is not really paying for some section getting a meeting room. The meeting room is paid for by that section. It's just done in a more global calculation way. But again, the most important thing probably to this body, besides the actual work, is that we bring strength to you. We help you identify issues. I heard the representative, Mr. Rose from the litigation section talking about, reviewing court rules. I think we heard Professor Straight do the same. Family law section does that as well. All the sections do. The Supreme Court relies on us to make comments on proposed rule changes in an organized fashion. You can't expect, when there's a proposed rule change that affects family law, for our 1,000 members of our section to somehow individually hear about these rule changes. Because not everybody reads the advanced sheets down to every single page. We can't expect our 1,000 or so members to write individual letters to the Supreme Court. Those individual members rely upon the sections through its executive committee to think these issues through and make cogent comments. And we do our best to do that. Can we make that easier? Well, we're talking about that this year. Does the section's comments have to go through the Board of Governors? Can it just go through the Legislative Committee? Or can sections just do it directly? I'm not sure that, I know that most members are not aware of the Keller deduction that we do. They see it, vaguely when they're writing their check once a year. But what they don't realize is that our Keller deduction, besides the calculation being objective, is right there on your registration, your renewal each year. If you don't want to pay for something the Bar Association is doing that you think is, according to the case law, non-germane, you deduct the amount of the Keller deduction. You don't have to ask anybody. You don't have to beg anybody. You don't have to do a calculation. You don't have to give a reason at all. You just take that deduction. Bar Association lives with that lesser amount of money. It is a solid approach that's been approved by courts in the past. And it is better than any of these systems that have been criticized in case law. Some people think that the Bar Association shouldn't be doing anything they disagree with or they don't have use for. Well, our value is greater than that. If you don't have a mental health, a drug, an alcohol problem, and you don't need the very limited service that the Bar Association provides to help members that are impaired, well, congratulations that you don't have those problems. But there are people that do. I know people that have benefited greatly from the program in the past. And the fact that it's there as a member benefit not only helps that individual member, it helps their family, it helps their practice, it helps their clients, it helps the court system. It isn't just there to benefit one person getting through a tough time in their life by getting some counseling. I think we've probably all been in court cases with people with mental health problems. I've had cases against lawyers with mental health problems, with alcohol problems. It puts a burden on my client, it puts a burden on me, it puts a burden on the judge I'm in front of. It's not just a problem for that person. So it helps our entire state if we have this little program that helps members. Will we have that program if our entire structure changes? No, we would have limited ourselves out of that. Free CLEs. Well, the Bar Association has done a great thing the last couple of years. They've been offering free CLEs. I take advantage of it. I know lots of people that take advantage of it. If you do, you look at the participants, you see an awful lot of people you know are participating in those little free CLEs. It's been a great program. Well, if the bar stops doing it, what's going to happen? You're still going to have requirements to attend seminars, but maybe you won't have that free benefit available. The organization has always struggled. There are plenty of people around longer than me, but and some even less than me. But there's always a push and pull with when people have strong opinions. And this organization is no different. I've been there for years when the board was fairly passive. I've been there when the board has been very activist. I've been there with staff that individuals that weren't competent. I've been there with staff that have been competent. It's a push and pull. It's a big organization. But these problems exist. Who's in charge of different things? Who should decide different things? Those sort of turf wars, they happen in every organization. We're no different. Structure change is not going to change the problems that this organization has on a daily basis. We will always have people who have personality conflicts with each other. We will always have turf wars. That's just part of the game. If you don't like being in it, and nobody does, you know, we can go back to, I can go back certainly to where I was 20 years ago. I paid my dues. I didn't care what the Bar Association did. Well, that has its detriment too, because I didn't get to have a say either. We will never have, for example, one computer system across the state for managing cases if we split apart. It's hard enough to try and get there now with all these different counties. But when you have an organization with people from all around the state, pressure can continue to be put to try and fix those things. David talked about the issues of Zoom versus live testimony, a huge issue in criminal law, I'm sure, but also a huge issue in family law. Well, by uniting, we can explain to the court, to the administrator of the court, the pros and cons. We can talk about people without adequate computer equipment to appear by Zoom. We can talk about the lack of availability of the internet in certain parts of the state. We can talk about the positives of people not having to go into dangerous parts of the state to go to court or take more time off from work. There are pros and cons of every topic. Having more information, more input is what is needed. I am just boring enough that I read all these cases that come down, and Julie Shanklin is good about telling the board and all of us what cases to read. I convey what I gain to my section. I report it to section leaders so that they aid us in our discussions. I feel strongly that we are in a good position if we are sued. I don't feel that we need to be afraid. We do not endorse political candidates. We do not run ads for political candidates. We are not like the, auto workers union or whoever are the unions that some people don't like. We are very careful with what we print. Even if I think it was Kyle talked about the Ninth Circuit. We haven't done what Oregon did in the case that's before the Ninth Circuit. Would the court would that case result in us having to completely change our structure? I'm optimistic that it would not. We might get ordered, or the Ninth Circuit might order Oregon, which would then be also binding us not to do that again, provide some clarity about what bar associations should do. But I'm confident that we're not going to throw out the baby with the bathwater kind of thing. Bar associations do too much good work across this country for courts to just throw them out. And if they do, we have other routes to appeal. But we should fight for our structure. We should not be afraid. We should not work on an alternate structure. It was one thing when there was a possibility that the U.S. Supreme Court would make a ruling this month, but they didn't. And they showed that maybe they won't. If they couldn't even come up with 4 people to take a case for review, why do we think they would have enough people to overturn the majority of the bar associations in this country? So I'm more optimistic. But even more importantly, to develop those 50 different options for a contingency plan would take us away from the work we need to do. We would be arguing over, okay, there's money in the bank, who gets it? Under what terms? Who manages it in the future? Does it all get split up? Does it get split up 26 ways or however many sections or committees we have? Who gets what staff? Do we just lay everybody off, then everybody gets rehired differently, new people? What happens to the furniture in this room? Does it stay with the Bar Association? Or do we each get our, 1/20th of that furniture? Those are huge issues. But while we're doing that, while we're spending hundreds of hours doing that, we will not have time to reach out to the constituents that we need to reach out to the organization we need to have ties with. It is a waste of our time. It's a waste of our money and might never, ever be needed. So let's stay together. Let's be a team. Let's keep doing the good work. We'll listen to you. You listen to us. Let's see if we can make things better without blowing it all up. I'm happy to take any questions.
Sorry. Thank you, Nancy Hawkins. Does anybody have any questions, thoughts, or comments at this stage that they'd like to share with respect to what Nancy Hawkins had to say on behalf of the family law section?
So you said Professor Strait had a thumbs up?
Yeah, Professor Strait had a thumbs up.
I think he gave me a passing grade about 42 years ago. So
we'll take that as an endorsement then. There, Governor-elect Kevin Fay has his hand up. Oh, was that a clap?
A clapping hand.
Oh, a clapping hand. Okay.
Thank
I
you,
have to
Kevin.
get used to all these little symbols again. Oh, Director Platchy. You're up.
Thank you. So I have a question, and this is for you, Nancy, but also probably for any of the section members, and I apologize for not asking the question when David was up, but I would, so it seems to me that the lightning rod question that's really floating over sections is around legislation. With all the past cases, Julie's done a good job of educating all of us. I've read the cases. The Fifth Circuit case is the one out of Texas that you referred to that talked about
the restriction of legislation to pretty much things around lawyers governing, kind of governing lawyer activity in court rules. They had a very narrow definition of what they considered germane for that in that circuit. The Ninth Circuit, from my understanding, is going to be taking up the freedom of association claim, which is almost the same claim that the Fifth Circuit took up. So my question, and I guess I'm just earnestly asking, is the section activities, and I hope Julie would agree with me, is most of the section activities are germane. Even under the Fifth Circuit's case, I think you can look at it and say most of them are germane. Everything almost you do is germane, with the exception under that case of the very narrow definition of commenting on substantive legislation. They very narrowly defined it. I don't know if the Ninth Circuit is going to do that or not, but in the spirit of thinking about this from a contingency standpoint, if the Ninth Circuit came down with a similar ruling to the Fifth Circuit, how would, and this isn't just for your section, and I hope the other sections listening will consider and think about this, how would that impact your section? If the Ninth Circuit came back and narrowly defined or commenting on legislation to be non-germane, if it's even on substantive things like family law or real property law, and it has to be within this very narrow bucket of lawyers, of how lawyers practice and court sort of activity. If that happened, would it so dramatically impact your mission as a section that you don't think you could continue on in this organization as an integrated bar if you couldn't participate in them? And that's if. I'm talking a bunch of ifs here, but I think that's, to me, the whole lightning rod of all of this is centered around legislation and commenting on it. And if the sections, for some reason, the court comes out and says that, are the sections so married to this idea of commenting on legislation that they don't think they could exist in this organization otherwise? Because everything else you do just about is germane.
So I thought you were going to raise the question of who gets you if we split up the bar association or the sections, or who has to take you. Maybe that's the question. You know, I think there's a confusion that legislation that falls within a particular arena, a particular subject like family law, is therefore substantive and therefore non-germane. And I think those are leaps that are not accurate, because you have to look at individual pieces of legislation. So would a bill that, what if there was a bill that said no one can have more than 2 children? Would the Bar Association do nothing because it was controversial or social? I would hope our Bar Association would jump in and say something like that's unconstitutional. If a bill is proposed in the arena of family law to require that parties going through a divorce have a guardian ad litem in every case involving a child, regardless of cost, is it substantive or procedural for the family law section to step in and say, to comment? We don't have to say we support a bill or don't support a bill, but can we say this is what it would mean because this is how much it would cost? Why is it so we can comment about a fee for filing a divorce, but we can't comment about a piece of legislation that would require an unnecessary and expensive step in the divorce. I think that, and I think our section, I'm sure all the sections are willing to sit down and work on why certain things should still be considered germane, and germane being the word in some of the recent cases, that they do have to do with the practice of law, the administration of justice, improvement of legal services. That just because, isn't that really true of almost everything? It's a question of, are we going to initiate a bill to require something, or are we going to comment on something that someone else initiates, a legislator initiates? I think we should not only make those comments, but we should be proud of making those comments, and we should argue for the right to make them, because it does affect lawyers across the state if bad laws come into being. It affects litigants across the state. If unfair laws, expensive requirements are put in place, whether it's in criminal law or family law. The bar got a lot of criticism for not commenting several years ago or being too late to the game on the State Bar Act. Well, would we have even had a legislative affairs manager if the whole structure had changed? Would you have somebody just sitting around waiting every 5 years for some challenge to the State Bar Act? I doubt it. That staff position would be eliminated, and all the others. So I would rather have common sense but supportive rules about legislative comments. Obviously, an individual member, I can go down to Olympia just for myself and say whatever outrageous thing I want. If I'm wearing a bar association hat, obviously there are some rules I have to follow, but they don't have to be a rule that you can't say anything. So I would say let's all work together to come up with some reasonable, not fear-based criteria for making legislative comments. What do you think, Kevin?
Any follow-up thoughts or comments, Director Platchey? No? Okay, I've got about 3 hands up. So Professor Straight, then Governor Stevens, and then Governor-elect Petrusek.
Let me see if everybody can hear me, I hope.
Yes, go ahead.
Yeah, thank you. Well, I generally gave a thumbs up to Nancy's comments because I generally agree with them, and I know that the board, which has discussed many of those issues, particularly the ability to comment on legislation and court rules, et cetera, given our bifurcated board and a supermajority requirement, we feel very strongly about that. In response to board member Platchey's question about could we continue to function under a system where we couldn't comment? Well, I think we could for many other aspects of what we do, but that's a significant part of why we exist. Indeed, one of the things that I've seen in the now almost 4 decades that I've been on that executive committee, I'm the only continuing and oldest member, is that over the years, we've all come to recognize, prosecution or defense, that there is, of course, in criminal law, always a political motivation for some new proposal, no matter how poorly thought through, no matter how negative its ultimate impact would be on the legal system, criminal justice system in particular. The nickname in the trade is Hero Bill. you read the headlines, you propose a bill to address something that isn't thought through, doesn't even necessarily go through the legislative drafting process. It just gets tossed in the hopper. And if we can get a supermajority, but prosecutors and defense counsel to point out what the implications of that are for the system, is that a voice that can't be heard or shouldn't be heard? It's doubly ironic to me that while corporations don't have to ask their shareholders before they take positions using, in effect, shareholder money to do so, as protected under the First Amendment, that a professional organization with mandatory membership, I understand the distinction constitutionally, would not be allowed to voice on matters that directly impact their function. One of the problems that prosecutors recognize in our section is that when a new crime is created, that has an impact on their day-to-day jobs. They have to deal with that. And if it's very poorly thought through and very hard to utilize in any meaningful sense, then isn't that something that the legislature should be told? Ditto from the defense side. And in our field, criminal law, this is multiple bills every session. Court rules is another story. That's a more balanced process, generally speaking. But even there, since the expertise of criminal law is not always present on all of the relevant committees, that's a voice that needs to be heard there as well. It would be, in my view, not impossible for us to continue as a section under the WSBA without the ability to comment on legislation. But I think it would be a terrible mistake and not constitutionally required. And I think that Nancy's request that we address that issue separately from the idea of restructuring the entire bar is the best way to go.
Thank you, Professor Straight. Let's see, Governor Stevens.
Thank you, Mr. President. And Director Platchey, I'm going to use my usual example as it relates to as being a former chair of the Civil Rights Law section. My usual example is, and in fact, it is not without the realm of possibility, given some legislation that's been going around the country. So in this hyper area of fighting against immigration and fighting against LGBTQ rights, a bill is dropped to eliminate immigration and sexual orientation as two of the areas that are covered under the Washington law against discrimination. It would be not only tragic, but it would be, I think, a dereliction of the duty of the members of the Civil Rights Law section to be in a place where we can't comment on that legislation. Because it is not only, to me, substantive, but it totally changes who our clients might be, who might want to bring a suit against discrimination under those two areas. But in fact, I think that points out the issue and the quandary that I have. And the quandary is, and it's something we just have to deal with. And I think that's why we have this effort going on about ethos. There are a number of our members who don't want us to say or do anything as it relates to the advancement of civil rights, even though a part of our mission is to be a champion for justice. But there are some of our members who totally disagree, who fundamentally believe that we should not at all get into that area. And each time we do, we've got to know that those members are going to raise their objection. And their objection is not only an objection where we talk about a Keller deduction that is not, quote, worth the or is not commensurate to the damage that they see of having to be a part of a bar association that that offends their beliefs as it relates to the areas I've talked about, for example. And therein lies the issue. And it's just an issue that I think we're going to have to struggle with. But it's a part of, I think, fundamentally the issue that if there are things that the Bar Association is doing I'm just borrowing some of the language now that's out there, this woke effort to assure that people's rights are protected across the board, then we're going to have that. But as it relates to the civil rights law section, I think this is the quandary for that section because of the work that we do and the issues that we have.
Thank you, Governor Stevens. Governor-elect Petrusek.
Thank you. So I concur with what Ms. Hoggett and Professor Strait said in terms of, I think that there are issues that sections can at least advise and inform the legislature on with, and maybe it means that we don't specifically say we support or don't support a bill, but it was pointed out that at least I think in this last legislative session that there were no lawyers or maybe only one lawyer in the entire legislature, which is odd because usually there are multiple and many lawyers in the legislature. But if there aren't those people there to inform the other non-lawyers, someone needs to be able to do that. For instance, you know, most of you probably know that I'm on the executive committee of the solo and small practice section. I'm past chair of that. And one of the main issues that we dealt with recently was the bill that was passed requiring every lawyer to have mandate malpractice insurance. We actually asked our membership as a whole if they supported that or not. And overall, the majority of them didn't. And what our executive committee took a position on is that for solo attorneys in particular, and even small firm attorneys, having mandatory malpractice insurance could actually put them out of business because of the steep cost of having to have insurance. And that is something that the legislature, frankly, probably would not even consider had we not been asked to be able to comment on it and submit our comments on that. So it's things like that that I think, would the fact that we wouldn't be able to comment on legislative issues be the end all of us being part of the integrated bar? No, because frankly, unlike the family law section, we rarely are asked to comment on legislative issues. And frankly, that's not our biggest reason of existing. And if we couldn't do that anymore, I don't think it would cause us to say we don't want to be part of the bar anymore. We find far more value being integrated with the whole bar and actually are afraid of what might happen if we were forced to separate from the bar. Thank you.
Thank you, Governor McBride.
Great. Thank you, Mr. President. And I won't take a long time on this, but in both my legal practice and in my experience, I've always had a lot of faith in what I call the difference between straw man arguments and steel man arguments. And by that, I mean, straw man is presenting your opponent's argument in the weakest fashion and with the most rebuttable presumptions. And steel man is thinking about what is the best case for your opponent's argument, even if they don't know how to make it. And because I actually think that works, I have kind of an open heart and an open mind about question 3 when we look at that structure. And I just want people who listen to this to understand that I don't think people who are advocating for change are necessarily doing it because they're scared of litigation or they're stupid or they're uncaring. I also have not heard a single person recommend that we are looking for a structure that allows us to not make comment on legislation or to not provide free CLEs. And so those are uncomfortable arguments for me to listen to and pretend they really get to the question we want to decide. I want to hear the best arguments, and I'm willing to consider them. And I'd like to follow up on something Governor Steve. Now, I'm a fan of having an opinion on everything under the damn planet. And so what if a structure allows us to have more comment and take more positions? And I know change is scary to people, but can we at least talk about it without setting this whole meeting up that somehow you're a bad person if you want to talk about a bifurcated or a hybrid bar? It might be better. We're kind of like a Swiss Army knife. We're pretty good at doing the mandatory stuff. We're pretty good at doing the optional stuff, but we're not great at either because we're trying to serve two masters at the same time. And I just think we ought to talk about it. And I have no belief that there's a desire to make a change this year. I'm not scared of litigation. I don't think we're going to be forced to do anything, but there might be a better way out there. And why are we so scared to actually treat that idea with a little respect and quit diminishing it and the people that advocate for it? So I hope you'll consider that.
Thank you, Governor McBride. I see our representative, the chair of the international practice section, is wanting to say something else.
Hi, I'm Ellie Baxter, the chair of International Practice Section. So in response to Kevin's question, what we would do if sections activities are not germane, and well, we will examine our activities, and if any of our activities are not considered germane, and obviously we cannot continue those activities. Well, I doubt if we have such activities, but if there are any, obviously we will not continue them. But we still continue the other germane activities. And if none of our activities are not germane, it is my personal opinion, but our executive committee will find germane activities suitable under the law, because I believe our executive committee can work to provide a great benefit to our membership, the members of the International Practice Section who practice cross-border international law. But it will be very difficult if we are not united. For example, providing 9 to 10 CLEs without integration every year, it'll be very difficult. And our unity makes these tasks so much easier to bring those values to our membership. And about Nancy's last comment, she said, let's stay together. So we often say, we pay section par charge to the WSBA. And before I started serving as a chair of the International Practice Section, I served as a communications officer of the section for 7 years. And during that time, please excuse me, but I had some frustrations about what the WSBA was offering, and I was thinking why the WSBA cannot do this and that for a section. And one of our past chairs, when he left the executive committee, which was right before I became the chair, he said, "Be nice to WISPA. They are our allies." And after I became the chair last October, I quickly found out that the WSBA, we pay our section par charge to, they work really hard, so hard that I am afraid to ask more things for a section, legitimate things. So I quickly learned that we should work with the WSBA with respect. So WSBA is a great allies. And yes, we pay section par charge, but we need to work with respect. And we work together. If we work together, we can provide great benefit to our members. And I believe that's how we can enrich our section and ultimately the entire section. Washington State Bar Association. Thank you.
Thank you very much. I see that our Chief Disciplinary Officer, Doug Endy's got his hand up.
Thank you, President Tollefson. I have a question for Nancy Hawkins or any of the section representatives or anyone, I suppose. And it's a hypothetical question, genuinely hypothetical, because I think it oversimplifies things somewhat, but I think as a thought experiment, it may be useful. When we talk about potentially restructuring the bar, I think mostly people imagine figuring out what the problematic areas are from a First Amendment standpoint, or from a germaneness standpoint, and sending them out into the cold, spinning them off and making them fend for themselves. And then the bar association the rest of the bar association remains and does whatever it does. So I'd like to flip that presumption and imagine a different restructuring model. And I want to just briefly go back to 1933 to remember what it meant to integrate the bar. There was a Washington State Bar Association, and under the State Bar Act, it was given the regulatory functions and expected to discharge the regulatory functions and authorized to collect licensing fees, make the Bar Association mandatory. So what if the alternative structure was flipping that switch back and taking the regulatory functions, sending them back to Olympia, saying Supreme Court and or legislature, here you go, figure out how to regulate the practice of law, form the Washington Attorney Regulation Commission. And the Washington State Bar Association remains intact. They get everything, the name, the chairs, the computer systems, but could no longer be a mandatory bar association, couldn't force lawyers to pay to be members. So it would become a voluntary bar association. In that scenario, what are your concerns?
Anybody have any thoughts or ideas about that? That basically is kind of what happened down in California, right?
No, California spun off the problematic aspects from a speech standpoint and pushed them into the California Lawyers Association. And the State Bar of California remained. And I'm suggesting flipping that a little bit, if you see what I'm saying.
Oh, got a hand up. There's Nancy Hawkins got her hand up. And then Professor Strait.
So Doug, I guess my first thought is you send all the regulatory functions back to Olympia, to the state of Washington. It's not like they're going to do it out of taxpayer money. They're going to say, okay, I want a fee. Gee, we're paying, $400, whatever it is now. That sounds like a good amount. We'll have you pay that. So everybody's paying the same amount. We all know the legislature is not going to cut the rate. It's going to be the same, I would guess. So then there'll be an additional fee for this maintaining of the bar association to do all the other functions. It's going to be an increased cost, and I think we've seen that. I think we heard about that is the result in California, that the combination is more expensive. Plus, as we have discussed and have heard, most of what sections do raises no issues at all. And yet, we would suddenly become voluntary even as to the things that don't raise concerns? Or would our CLEs go to Olympia, but not our legislative comments? So we have, in effect, the family law section has to have two groups. I don't think it solves the problem. It would be more expensive for lawyer members.
Professor Straight.
When you say send it to Olympia, do you mean simply say, okay, Supreme Court, you're exercising your inherent power over who can become a lawyer and how lawyers' standards are to be applied and disciplined? Is that what you have in mind, or dumping it to the legislature?
Well, my hypothetical was not that granular, but what I was thinking was a model along the lines of the Illinois system or the Colorado system, where the purely regulatory functions are under the umbrella of the court system.
Yeah, and I guess that's one of the concerns I have. And this won't be new to you, Doug. A system that operates its regulatory functions entirely outside of the Bar Association, I think loses significant input that does affect what all of us as members of the bar experience. And I'm referring specifically to discipline and in the function that I serve a great deal of time, admission. And the Supreme Court is unlikely, in my view, if it goes there, to restructure the existing offices. It will simply take them over. And that's still one more step removed from the actual folks impacted by them. I am not keen on that model. I don't think it's the best. I think there are many issues, which I won't certainly discuss today, about how admissions standards are implemented and how the bar investigates and prosecutes disciplinary matters, your field. But I do think making that completely independent of the Bar Association is a very unsatisfactory solution, and I would not speak in favor of it.
Governor Couch, you had your hand up.
It's funny, this question that was asked is actually an argument I have had repeatedly with Josh King, who, for those who don't know him, was the former general counsel for AVO. And where he came down was essentially that he was of the belief that there was a fundamental problem in lawyers regulating themselves because they were incapable of thinking about anything other than self-interest and actually doing work for the public. And I disagree with him on that and told him I was going to make it my mission to prove him wrong. I think we are one of the last industries that is self-regulated, and in the last country that still has this industry be self-regulated. I think it is a privilege that allows us to have a say over our future that is more in depth than we would if this regulation was taken away from us. And I think there is value in that. I think we are capable of doing that. And I think really, we are, if we can have the right mindset, we are the best suited people to regulate lawyers because we have the best understanding of what lawyers do, as opposed to the legislature or a different created body by the Supreme Court. And so I think it is a privilege worth holding on to. That's my thought.
Well, I've got two people that want to talk real fast here, but I'm going to let General Counsel Julie Shanklin speak first.
Oh, I didn't really need to butt into line, but so I like the idea behind Doug Enday's question because as I understood the court's question number 3, it was pretend we're in a world where there never was any integrated bar litigation, right? And that's kind of what Doug says. Go back to 1933 when the State Bar Act was created. Why is the stuff that's in there? The thing that appears to me to be missing from this conversation is, and one of the things I've noticed is I believe almost everyone that's spoken has talked in terms of solving the problem. I think question 3 from the court does not presuppose there's a problem. Question 3 says, if you had a magic wand, then you could go back and create the Bar Association any way you wanted. Would it really and truly be exactly like it is? Or would it be different? And I think in order to
to answer that question, maybe we need to think about what are the purposes of the bar. Do we have it right? Do we have it wrong? I think our thinking is very narrow, and maybe that's my role, is to blow things up. Sorry, I wasn't really intending to do that. But, we're here with a lot of people that have a lot of diverse viewpoints. And I think it's somewhat unfortunate that we're all focused on, a very narrow set of comments about solving problems. What are the most important things that a bar does? Why is it important to have an integrated bar versus whatever these other models are? I think maybe broadening the discussion around those areas might be really informative and helpful.
Thank you. Past President Schicchetti.
Thank you, President Olson. In my opinion, this is kind of getting to the crux of what we should be looking at and what we should be deciding. For the last year or so, as I've been thinking about this issue, it occurred to me that the most likely scenario is, and the what if that was posed by Chief Ende, that the WSBA continues, although just in structure, in everything except for mandatory fees, is probably the most likely scenario if we bifurcate. And so last year, when I had my opportunity to visit a few different communities from around the state, I thought about and wished I could have done more, because the question I would have liked to ask folks in Eastern Washington, North Washington, Southwest Washington, all over the state would be, for those people who are in favor of bifurcating the bar, would you still be in favor of that if you had to pay more to do so? And my thinking was, and I'm hoping that we can hear from the Colorado Bar Association, because I think that's going to be very instructive for us. But I would think that there would be a lot of overlap between the regulatory side, the mandatory side, and the voluntary side. So if you peel off the regulatory side, they're going to need to have their own systems, their own staff, their own programs, including most likely DEI and programs that are influence the access to justice and administration of justice. So all of that is going to be under a government entity of some kind, either the Supreme Court or the legislature. And members don't have any control over that. And then you'll have the voluntary side, which I would hope would be the sections. And the WSBA would continue to offer the great work and services, including the work of the sections. But there's going to be a lot of duplication. So I would imagine that the mandatory side would have, $400 a year. The voluntary side, maybe another $400 a year. I had an occasion a few weeks ago to talk with a bar member from North Carolina, and I understand from his bar that's exactly how it works. You each have more, and sometimes counties have their own mandatory bar associations. So the combined fees in North Carolina was about $1,000 for some attorneys to practice. And I wonder, and I'd like to, hear from members from around the state, and maybe we'll do this next year in the listening tour to talk further. But the question I'm going to ask is that worth it to you? Is it worth it to have a voluntary side and a mandatory side, and the additional expense that is associated with it, so that you don't have to pay for non-germane activities? I'd love to hear the response to that, because it may be it's more important that I don't pay for things that I don't believe in, and I'm willing to pay twice as much in order to achieve it. But I'd love to hear other people's perspectives on that.
Governor Williams-Ruth.
Thank you, Mr. President. So first thing I want to do is make sure that everyone knows that there is an organization called the Washington State Bar Foundation. It is its own separate legal entity that raises money for some amazing projects, including the Powerful Communities Project. And that entity is associated with the Washington State Bar Association, but it's not the WSBA. They do not have to have their own space. They do not have to have their own microphones. There is a structure that's in place that has worked well, at least by my understanding, of how there is a symbiotic relationship where there is mutual benefit to everyone. It's even every single member of the WSBA can even choose to make a tax deductible contribution through your licensing forms. And that money gets magically, through the work of good people, put into the right pots, which I will just take a moment and say that this year the foundation was doing a stretch goal of $300,000. We're almost there. So if you're here and you're this invested, have you made a donation yet to the foundation? Because they can do a $10 per month recurring charge, which would help us get to our goal. That being said, and I'm not actually wearing my foundation pin, but I am a trustee on the Washington State Bar Foundation, just to clear up any potential conflicts. The issue for me, and having served this past year as the chair of the board legislative committee, comes down to GR 12.2 C2, which says, for those who have not memorized it, the Washington State Bar Association will not take positions on political or social issues which do not relate to or affect the practice of law or the administration of justice. Now, I've heard a couple speakers use some of those phraseologies in the hopes of bringing this in, saying that it's everything that we're doing right now falls within that. The problem is there's really not a lot of clear case law. And in fact, the one case that I would invite everyone to go read is Gibson v. Florida Bar, 798 F. 2nd, 1564, where cert was dismissed from the United States Supreme Court. And I can drop the whole link into the chat later. But it comes down, and that is the case where the court concluded that.
Tell Brianna to come out. I'm going to stay in the car and listen to this.
Excuse me, somebody's got their mic on. Could you mute your mics, please? Go ahead, Governor Williams-Ruth.
Thank you, no worries. In that, the court noted that the application of germaneness would be of little assistance when one of the purposes of the bar was this amorphous administration of justice term. And the court concluded that improving the administration of justice should be interpreted as pertaining to the role of the lawyer in the judicial system and in society. Again, not ideal, not the silver bullet that will help clear up everything. But I look back at where we've taken positions. And again, as a governor, the sections to whom I liaise do a lot of work that does not fall within that realm. And last year, not this past 2 months ago year, but 14 months ago, the board legislative committee passed the idea of supporting a position on definning sharks and shark hunting legislation. Now, is it the right thing to do? Is it the right thing to stand up for? You bet. Does it fall within GR 12.2? I have a real hard time with that. And though we can argue things out in federal court, I wonder if that's really the best place. So again, I take the comments from Governor McBride because there seems to be this belief that what is out there is an absolute extreme of the situation. And I like the idea of saying, if we were recreating everything from scratch, where would we do it? And having just returned from getting to meet colleagues from 16 different Western bars and learning the different terminologies. And in fact, just this past week, we had an executive committee meeting where terminology was used, where I had to ask Executive Director Nevitt for clarification. because there's the terminology of mandatory or integrated or voluntary and then hybrid bars. All of these terms are evolving and are meaning different things. For example, I would have presumed that the California situation right now, which has the regulatory side, and then their sections, as 100% of the sections are in their own organization, would have been deemed a voluntary bar. But it's actually considered hybrid, and it's because at the end of the day, the top of the pyramid in the California bar is not the California Supreme Court, but the California legislature. Had no idea that that even went into what we're using for these terminologies. And so I don't like the fact that we are standing behind flags and terminologies when I think that what could happen is we're not really understanding exactly where we're wanting to be. Because for me, I believe as a governor, my duty is to, fiduciary duty is to ensure that we try to avoid being hauled into federal court. And, there are a multitude of issues, and Governor Stevens has raised them and others as well, that, it's just that there's a lot of bad bills that are going on out there. In fact, this morning through social media, I saw a bar member talking about how she's incredulous that the attack on women's rights, on families with trans children, on books, and it's just absolutely insane. And just yesterday, we had a state take action against a private corporation because they didn't like the words they were speaking, even though the Supreme Court says that our corporations can speak. So, it's one of these things where I saw the comment in today's packet from the business law section. And I was excited to see their contribution because it was one of their bills this past year in November of 2021, where we endorsed the bar bill, which was the updating of the substantive update to the Uniform Corporations Act. And in the correspondence from the business law section, it was phrased in what they were hoping to do. And it was very nice and very easy for someone like me, where I could hone right in on their bolded print about what they would like to see. And I said, if you could see all of that. So I will say, I picked up the phone, I called the chair of the section. I said, if you could see all of that, but done with some behind the scenes changes regarding where legislative activity or non-germane activity would rest, would that still be something that's worth considering? And and the conversation was great because, again, the fear that's out there is that there's going to be a complete divorce and separation, when I believe there's a whole lot of other gray area where simple things can be cleaved off, put into its own protective place, because I am someone who wants the attorneys of Washington that don't have the power of their own lobbying group to be able to have a place that they can come and speak to the legislature. I tried before joining the Board of Governors to get laws passed to put teeth into some of the statutes that relate to death and dying, because that's my area of practice. And I got out of committee with bipartisan support, but then got stuck in the Rules Committee. Now, maybe if I had a professional lobbyist, such as our legislative affairs manager here at the bar, if I had known that the section was working on this, then it could have passed. But again, it was a substantive change to the law. I want to see the subject matter experts coming in and being able to provide it, but I don't want to do it shyly. I don't want to have sections having secret coded conversations with legislators because they don't want to follow the process, or they're not sure it's going to be able to get past a GR12 analysis, because that doesn't help anyone. Yesterday, a very good friend of mine discovered that a church she's been part of has a rule that when a pastor retires, for a period of years afterwards, there's a complete and total silence and break, unfriending from Facebook, no more following Instagram posts. And he was just devastated. And I said, hey, I only knew about it because I joined that same church a week before somebody who'd been there for 40 years was to retire. And then I watched the fallout. I know what you're saying, but I wasn't connected, so I didn't have the thing, but I knew. And his issue was that nobody told him. Now, what does that have to do with anything? I'll tell you that I switched careers and changed my entire practice of law, started to self-teach, actually went back to Seattle University and audited a course, as an alumni has the right to do, to get into a new practice of law. I joined the section. There was never any communication about the section's rule and role in legislative activities. So this goes back to the earlier comment of the executive committee taking things on behalf of their members. They do, but do people who are new to the section or who haven't been involved know about it? Because if I had known that my section could have helped with that, I would have gone to that person and said, hey, I've got this situation. I've got a client that's been really harmed. And I think we can get a real support and get this changed. So there's all of that is to just say that there's still, there is no perfect actions. We are all human, but I think that we're missing an opportunity to really look at how things would be made. I mean, in my house, we did a lot of baking during the last couple of years. And there were some times when things came out of the oven and they got thrown in the trash. You start it again. And then there were times where you could taste as because anyone who's difference between baking and cooking is a art, baking is a science. And so you go to taste that thing that you're cooking for dinner, you're like, ooh, I could use some salt, maybe a little cayenne, and you can adjust and make things work. I think we need to be thinking about throwing everything out and starting it, but not actually doing it because we're not baking, we're cooking. But if we don't give ourselves the mindset of, if we were starting from the beginning, how would it look? I think we're really missing an opportunity in the hours that we're putting forward. And so it's all of this is to say is that there has been so many different inputs, and I will echo the fact that many people have reached out to me personally to advise that they don't feel that it's a safe place to engage in conversation. And that's why I just continually urge people to come to these forums and have that opportunity to be heard. So I thank you, and I look forward to the rest of the comments.
And Chair of the Practice of Law Board, Mike Cherry, who's got his hand up.
Thank you, President Tollefson. And I raised my hand because according to the agenda, this is now, we've sort of crossed into the time for boards. And I know you've been respectful in trying to determine if the minority bar people have been represented and everybody else has been represented, and I appreciate that very much. Speaking from the Practice of Law Board and speaking as the chair of the board, and I have been talking to members of my board about this matter. When we responded to the RSVP for this meeting, we received back an email that asked us two questions. What does the bar provide to the boards which is helpful? And then what does the bar do which provides challenges? So I'll start with what does the bar do which is helpful to the Practice of Law Board? And most importantly, what the bar does is it gives us access to incredibly knowledgeable resources that, were we not to have a statewide bar, we would not have such access, because the knowledge that these people hold is quite important, but it's very specialized as well. And were we to have many bars competing for this resource, we would be in competition with each other to gain the skill sets that the bar has accumulated. This is in the area of professional responsibility, corporate counsel, admission to practice, and in the provision of services to the members of the bar. I think that's very important to keep in mind, that there's a lot of specialized information and it's specialized skill sets that come to bear in this area. And if we were to compete, that would be difficult. In addition, I'm very worried about the concept that were we to create a bar that was functioning on the sort of the court mandated discipline and admission to practice and those areas that are regulatory. And then we said that other services would be provided by the other bars. I'm not convinced that there are volunteer bar associations across the entire state. What do the more remote counties do? You know, what would happen in Ponderay, in Ferry County, in Stevens County, and even in King County, because I've had members of the LLT practitioners that are LLTs come to me and say that some of the community and county bar associations do not recognize them for membership because they are not lawyers. And so we could orphan legal professionals who we have licensed were we to not be a state bar. The Practice of Law Board gets tremendous help from the Bar Association, and we could not do our job were we to have to, on our own, try to create the services that we get. We would have to have our own communications department. We would probably have to have our own legal counsel. We would probably have to have somebody with the caliber of Doug Endy advising us on matters of the law where we, as volunteers to a board, do not have the requisite skill sets, nor could we acquire them easily. So that's in summary what is very helpful. I'm going to be frank about what is the challenge that the Washington State Bar Association creates for the Practice of Law Board. And that's simply that we're not able to move at the speed we would like to move. And it's not just that we would like to move at that speed, but I think is necessary for us to be moving at due to changes that are occurring external to the Bar Association with regards to the market for legal services. There are a lot of things happening that we should be thinking about in terms of legal regulatory reform. And while these internal discussions about our structure are no doubt important, I don't want to say that they are not important. They are taking up an incredible amount of time. And the time which we ask of our governors and of our staff and of other people, people like Nancy Hawkins, who is incredibly knowledgeable and incredibly works so hard to represent the sections. All of this focus on our structure, I think, is delaying things that we should be looking at in terms of access to justice, in terms of diversity, inclusion, and equity of our profession, of the equity of this profession, and the laws that need to be rethought because of their consequences as we change and become more socially aware of the history and perhaps systemic racism and other issues that have happened. But we have to ask ourselves this question: as a legal profession, are we keeping up with what the public needs from this profession? And that's where I would ask the governors to please continue to focus on, and please work for ways that we can be moving somewhat faster on these matters. We already have, gaps between meetings where we're essentially waiting for when we can present items to the board and get information and get feedback from the board on what we're doing. All that said, thank you for your time today, your time over the last months towards this subject. I hope I've represented for at least one board, the Practice of Law Board, why this is such an important topic for us and why anything that greatly changes the structure of the bar, unless it addresses issues of timeliness and getting us the resources we need, would be of severe harm to the Practice of Law Board's ability to do its job. Thank you.
Thank you, Chair Michael Cherry. Do we have any other representatives before I get to Governor Treasurer Peterson? Do we have any other representatives of other Supreme Court boards here? Is anybody here from the LLT board? Anybody here from the Access to Justice board? Anybody hear from the other boards that Supreme Court has created that the Bar Association is responsible for administering to? You could hold up your hands, virtual or actual. Well, it's only 11:19 and I think we scheduled an hour till 12:05, so maybe somebody will show up. Treasurer Peterson.
Yeah, no, thank you, President Tolson. I guess when I'm here at these meetings and very helpful, very informative, but at some level, I think I agree with Mrs. Hawkins. I think the current structure and the current organization is very good. So, if we're going to make a change, and I'm definitely open to the idea of making a change. What's the compelling reason to make the change? And the way I conceptualize it is with the deny of cert for the Supreme Court, the imminent threat, is essentially gone. I mean, I realize Crow is out there, and there's a super small chance that someday that may create an issue, and we'll definitely have to keep our eye on it. But going back to what I think Governor Williams-Ruth and others have said, I mean, it's really kind of coming down to a GR-12 issue, right? So do you split the bar because of GR-12? And maybe the answer is yes. I guess I would ask people, why can't we just amend GR-12? And I guess I'd say under the current structure, people can already set up organizations that aren't bound by GR-12. We have the Washington Legal Foundation, we have DRAW, we have the MBA, many different sections on the MBA that aren't part of WSBA, aren't bound by GR-12. They can say whatever they want to the legislatures, and I think that's great. And I am concerned about, being able to, talk to the legislatures and that the distinction between substantive or non-substantive. But I guess my concern is if we were to split the bar, and I do agree that I think putting the mandatory the compliance and emissions and stuff under the Supreme Court, I'm not sure. I don't feel that's the right answer. But to say we split, we have a voluntary and compliance emissions goes somewhere else. My belief is that if we had, even under the voluntary side, Washington State Bar Association sections, they would still be bound by GR-12. And we really haven't solved anything, because even under the current system, any group can do a section that's not WSBA and talk directly to Supreme Court. So going back to my original point, well, it sounds like we have a GR-12 issue. So why don't we just amend, why don't we just potentially talk about amending GR-12, other than, instead of doing all sorts of different things that really weaken us in a lot of ways, don't make us better, and what it sounds like doesn't solve the problem we're trying to solve. Thank you.
Thank you, Treasurer Peterson. Do we have any other representatives of any of the Supreme Court boards here today besides, I haven't seen any other hands. We got Governor Stevens. Oh, and I wanted to ask Governor-elect Kevin Fay, you had your hand up for a while and then you took it down. Were you still interested in talking at some point? But we're going to hear from Governor Stevens first.
Thank you, Mr. President. And this is just to let you all know, we do have this equity and disparity work group, and it is going to be bringing a proposal probably regarding GR-12. But I wanted to point out that while I understand the idea of, well, let's just take a look at that, I would just suggest to all my colleagues that I don't think that really just resolved the issue. You are still going to have people, even with making that change, who are still going to have the issue of whether or not we should be doing X or Y or Z anyway. And I would just say, so Governor Peterson, be patient. Something is coming, but whatever it is not the silver bullet to the issues that we're discussing on why we're taking a look at the structure anyway.
Thank you, Governor Stevens. Governor Couch.
Yeah, Treasurer just reminded me of this and made me think about this. But as we've been talking about what could be gained for the sections in being able to comment on legislature, one thing that I think needs to be discussed as well is what is lost there. And I think that might help shed some insight as to why the sections aren't all jumping up and down saying we want to be able to comment on more legislation. And the reality is GR 12 and the Washington State Bar rules around it give our comments value that they would not have otherwise. There is nothing that prevents the solo and small practice section from getting together and saying, you know what, we want to comment on this, but it doesn't pass GR 12. So we should send out something to all of the members who want to sign on to this proposal, and they should sign it on and they should send it in. I believe we've done that before, actually. Many times. The Young Lawyers Committee often had a couple things that we couldn't get the entire bar to sign on to, but we said, you know what? We believe in this as individuals. We're going to write something ourselves, and we're going to send it out to some members to see if they want to sign on to it. And that's an acceptable thing to do. But if we take away the legislative activity that sections get to do and take it out of the Washington State Bar, we need to not forget that that takes away a lot of the value of that activity. If it is a group of solo and small practice members or solo and small practice practitioners commenting on something, that is different from the Washington State Bar commenting on legislation. And so removing that can also remove a lot of what we get out of it.
Have we determined whether, oh, by the way, thank you, Governor Stevens. Oh, there we go. There's Governor-elect Fay. And then we have, and then Nancy, did you have your hand up? Okay.
I just wanted to make a couple of points here. One, when we're thinking about what would the optimum structure be, and we should think outside the box and look at all sorts of other possibilities, it's really rather binary. I mean, we either have an integrated bar or we don't. And if we don't have an integrated bar, there will be some bar association over here that will do the non-germane activities or the non-core regulatory activities. And the question I have is, would that be viable in the state of Washington? I compare us with California. California, they have a voluntary bar that provides services. They have about a 70% take up, where 70% of, and it's going down. Would there be a viable statewide voluntary bar in the state of Washington? And I don't believe there would be. Unlike California, California has 6 standard metropolitan areas with over 1 million people. We have 1. And, the politics in Washington, you've got King, Pierce, Snohomish, and then you've got the rest of the state. And the rest of the state is not going to support a statewide bar association. So, my crystal ball is not any clearer than anyone else's, but I just don't foresee that happening. We have other bars. There's King County Bar. There's Association of Corporate Counsel. There's any number of voluntary lawyer associations in the state. Would they be able to do what we do as far as benefits to the membership, such as, substance abuse, such as legal research? I don't know. But it would cost more in the end to give the same services statewide. So I'm not sure that's a good idea or not. The second point I want to make is we do have Crouch on the horizon. And yes, the Supreme Court denied cert, but The Supreme Court also has not addressed the freedom of assembly issue. There are people in Eastern Washington, and probably in Western Washington as well, who don't want to be associated with a group of people who like gay people. It just shocks their conscience, and they hate having to spend money on a group that espouses the values that people in the WISBA do. And they may or may not have traction. I'm just pointing that out. We could, now out of the Ninth Circuit's probably unlikely, but that is an issue that could come around. And that's all I have to say about that.
Thank you, Governor-elect Fay. Anybody else got their hand up at this point? Do we have any other representatives from any of the other Supreme Court boards here? Not seeing any hands up. Well, we have about 35 minutes before we're supposed to break for lunch. Oh, I'm sorry, Nancy. I'm so used to looking at the screen and looking for virtual hands that I keep forgetting there's real people in the room. How about that? Nancy Hawkins, please.
So a lot of the talk over the last hour has involved a focus on how sections maybe don't follow GR12 or want to do a lot of things that would violate GR12. And I guess I wanted to kind of switch that focus because it makes it look like the whole need for structure change is because of sections. And I don't agree with that. So I'll make a couple points. With regard to the Supreme Court boards, for example, we're currently dealing with this idea of the Supreme Court boards that believe that they should have unlimited staff assistance, that they're not bound by GR12, and they can say or do whatever they want. Well, that raises far more issues of germaneness or lack of germaneness than anything a section has done in my memory. But there are also many dozens of things that the Bar Association does that no one does a GR12 analysis on. Is the Apex dinner and awards, are those compliant with GR12? No. It was a fun event. It's nice to get awards given out to worthy people. But was there ever a GR12 analysis? No. Is it a requirement under GR12 that the board meet at Skamania or the Davenport or any of the other fancy places that the board meets at? No, they like it. It's nice. But nobody does a GR12 analysis as to why, meeting at Skamania is better than meeting at the Red Lion. Whether, it's what we do, but for some reason, the GR12 analysis only seems to fall on the heads of the sections. And sometimes it's only the family law section or the criminal law section. So if we're going to really start lopping off things to do because of GR12, which I certainly hope we do not, think about the other things that the bar does. And I think that the overall membership is far more worried about some of the things the board does that have nothing to do with legislation then about whether or not sections give reasoned comments to legislators about proposed legislation. Thank you.
Thank you very much. Governor Stevens.
Yeah, I just wanted to state because at least for me, and I'm responding to what Ms. Hawkins just said. I think we were listening to sections and boards, but certainly I can point out, for example, a few years back, and in fact, kind of in response to the issues that were taking place in Oregon and Crow, the Board of Governors got a proposal and a request from the Diversity Committee to speak out to restate our opposition to white supremacist activities and threats that were made to especially bar leaders down in Oregon. So I would just think it's because of the area of who we were asking to give comment, less than just this is a GR12 problem. And in fact, if you recall, I just responded to Governor Peterson. I don't think it's just GR12. I do think there is across the board a number of issues that people or that some of our members are highly agitated about a number of the things that we do. Agitated about what goes in bar news, agitated about some of the positions that the Board of Governors may take, agitated about travel or whatever, but it comes back down to actually, I believe, and my colleagues may disagree, that what we do to give relief is not sufficient for those who are in opposition to any and all of those activities. That they want to see a bigger hit, they want to see a bigger way to rein in WSBA, and I'm saying WSBA now as the quote monster WSBA that I have to be associated with, and I shouldn't have to be associated with. So, I would just point out that, at least from my perspective, I don't think we were picking on or just looking at the sections as opposed to hearing from the sections and their views. And I guess I would also say that I think this is a process where we hear from everybody before we begin to decide. And I think the jury is out on, where we're going to come down. It may be that we decide to do nothing, but it may be to do something, and that may not be necessarily the total bifurcation, but something else that works. So those are my thoughts.
Thank you very much, Governor Stevens.
And I appreciate.
Oh, sorry.
I'm sorry. And Ms. Hawkins, I appreciate your most eloquent remarks when you spoke to us on the various issues you did. Thank you.
Thank you, Governor Stevens. Well, we've got a few more minutes for some folks from the different Supreme Court boards to show up and share with us what they think is going on and what we ought to be doing. I don't see anybody yet. Governor Stevens, you got your hand up again? Director Platchy's got his hand up. That's good.
Thank you, President Tollefson. I would just like to share with everyone. Oh, can you hear? Can you hear me? Thank you. I'd just like to share with everyone online and in the room that on the heels of the discussion we've been having about different scenarios, that we are going to be going over some various scenarios in the next meeting. So I would encourage anyone that's interested in hearing about different scenarios along the continuum. And I think they go along the continuum of, you know, what would it look like if there was a full bifurcation versus something in the middle, like I think Governor Williams-Ruth was alluding to with the foundation, where there's a sort of middle road thing, and then moving it completely regulatory, completely under the court. And I think we're going to try and get as close as we can. And I want to say this very carefully, because the modeling we're doing from a fiscal standpoint is going to be pretty broad, because we don't know all the assumptions or how specifically things might land, particularly under these different scenarios. But if you're interested in that discussion, I just want to flag it for those who are here and listening, and make sure that if you're interested, that you attend our next meeting, because those scenarios are on the agenda, and we're doing work on trying to model those right now.
Will that be in June?
May 21st, I believe.
Yes, the May meeting.
Okay, anybody else have any comments, thoughts, or questions, or should we? Well, here's my thought. We didn't take a morning break. So we've all been here working together pretty consistently since a little after 9 o'clock. So I think we should reward ourselves with an extra large lunch break and come back at 1:05 and reconvene with the understanding that we're going to get input from Alliance for Equal Justice community members. I'm sorry, 1 o'clock. Did I? Yeah, 1 o'clock, not 1:05. 1 o'clock. So that's my suggestion. Anybody have an objection to that? Governor Stevens.
Yeah, I don't have an objection. I was just wondering, and this would be for Tara or Shelley or somebody, did we ever hear back from any of the minority bar associations, or will we just have to re-look at inviting them again?
So I haven't heard anything specific. We did correct the link on the website and every place that it appeared. And I believe that the email that went out to the diversity listserv was correct, although I'm not 100% confident about that because I haven't been able to find it to double check. Regardless, certainly we can create additional opportunities, and there's already a planned opportunity for the July meeting for comment. So we can certainly create additional opportunities. And also we did send out a form to ask for people who were interested to comment to let us know. There was one commenter on there, so who was a member of a minority bar association. So we'll follow up directly with them.
And along those lines, and maybe between Governor Angeville and Chief Singleton, maybe we can even have an offline but sit down with a few of us with the MBA kind of leadership group to find out if there's another way we want to get their input.
That's a great idea, Governor Stevens. I'm on board with that.
Okay, anybody else have any thoughts, questions, comments, editorials? Okay, well, let's go ahead and break for lunch. It's almost 11:45, 11:44 and a half. And then we'll return promptly at 1 o'clock this afternoon. Thanks, everybody.